to improve home and personal security. These include additional locks, alarms, sensors, fireproof letterboxes, panic alarms, CCTV cameras, mobile phones, etc. In addition to the criminal offences I've mentioned, bail conditions can be imposed to prevent the accused from approaching any witness, and in appropriate cases, police forces can apply to the court to grant an injunction or an antisocial behaviour order against anyone intimidating a witness. We have invested in a programme of training which is available to all officers, and the Victims Code and the Witness Charter require all agencies to identify vulnerable and intimidated witnesses and to work together to provide them with an enhanced service. If the witness is asked to give evidence orally in court, and he or she considers that he or she needs assistance when giving oral evidence because they're in fear of distress of testifying, the prosecutor can apply to the court in advance of the trial for special measures to enable them to give their best evidence. And those special measures include giving evidence by live link from outside the courtroom or giving evidence with a screen around the witness box. Both these measures prevent the witness from viewing the defendant. In cases of intimidation, an application may also be made for the public gallery to be cleared, so that witnesses can give evidence in private. Decisions on special measures are a matter for the court to decide after taking into account the witness's views. So when a witness fears that they will be harassed and intimidated in the court building, if the court is notified in advance of the particular needs of the victim or witness, the court will endeavour to meet those needs wherever physically possible, for example, entering the court by a different entrance from the public and arranging separate seating inside and outside the courtroom. If certain criteria set out in the Coroners and Justice Act 2009 are met, the court may permit a witness to give oral evidence anonymously. The defendant retains the right to cross-examine the witness to test their evidence, but the identity of the witness is concealed. The legislation imposes 3 strict conditions before a witness anonymity order may be made. These are that the measures are necessary to protect the safety of the witness or another person, to prevent serious damage to property or to prevent real harm to the public interest, that they are consistent with a fair trial and an interest of justice-based test. And additionally, before making an order, the court is required to take into consideration the general right of a defendant to know the identity of a witness. And while the legislation does not stipulate that witness anonymity is an exceptional measure, in practice they are considered to be so. The Court of Appeal in the case of Regina v Mayers explicitly refers to the exceptional circumstances permitted by the Act. So I hope that as far as the Ministry of Justice is concerned, my honourable friend can see that the whole issue of protecting witnesses is taken very seriously, and I know because this case did not proceed to trial, these measures did not come into play, but I hope it is some reassurance to my honourable friend's constituents that the issue of witness intimidation and protecting witnesses is taken very seriously, and we do have significant powers to try and provide that protection.
I thank my honourable friend for his remarks so far. But does he, just to confirm on the record, does he agree that it was wrong that my constituents who had reported this, what was going on, that their details were subsequently handed on to the accused concerned?
Appropriate intervention. So let me turn to where the two issues related to that, because the Department of Work and Pensions does operate a scheme where members of the public can report benefit fraud anonymously, and that can be done online or by telephoning the National Benefit Fraud Hotline. And the Department of Work and Pensions do not disclose the details of people who report fraud, but make it clear they wish to remain anonymous. They are treated as informants, and their identities will only be revealed if the court orders disclosure. And I appreciate my honourable friend's concern for his constituents. They feel that they have suffered as a consequence of their willingness to perform a public duty. And I am very sorry that they feel that they have experienced profound difficulties and quite understand their concerns about the way in which they believe the Department for Work and Pensions has dealt with their case. And of course, this disappointment will be redoubled by the fact that Mrs. Horton was a former employee. But if anyone is not satisfied about the way Job Centre Plus has dealt with their case, it is open to them to contact the independent case examiner for a review of the case. The independent case examiner acts as an independent referee for people who feel that a number of government agencies or businesses have not treated them fairly and have not dealt with complaints in a satisfactory manner. These agencies or businesses include Job Centre Plus. And if the independent case examiner accepts the complaint for action, and if it cannot be addressed without full examination, an investigation officer undertakes a review of the paper evidence provided by the agency or the business concerned. The officer then considers whether the complaint can be settled through mediation. And if mediation is not appropriate, a report is submitted to the independent case examiner, who will consider whether there is any evidence of maladministration. And if there is evidence of maladministration and the agency or business concerned did not offer redress before the referral to the examiner, then the complaint will be upheld. Complaints must approach the independent case examiner within 6 months of receiving a final reply to their complaint from the agency or business which they consider to be unsatisfactory. In the case of my honourable friend's constituents, I understand that the final letter was sent to him by the Chief Executive of Job Centre Plus on the 31st of August last year. This letter explained that the independent case examiner offers a free, impartial resolution service and gave details of how he may be contacted. Therefore, my honourable friend's constituents have until the end of this month to initiate this complaints procedure should they wish to do so. And if a complaint is made, and should the independent case examiner find that there was maladministration by Job Centre Plus that caused them hardship or suffering, I understand that the agency can consider making an ex gratia payment. The honourable member also complains about the way the Information Commissioner's Office has responded to allegations about breach of data protection legislation in the way about information about his constituents was handled by Job Centre Plus. And the government takes both the protection of personal data and the effectiveness of public bodies, such as the Information Commissioner's Office, very seriously. But the Information Commissioner's Office is an independent public body set up to uphold information rights in the public interest. And because of this independence, it would be inappropriate for me on behalf of the government to comment on the Information Commissioner's Office handling of any particular case. However, if having exhausted the Information Commissioner's Office case review and his own service complaints procedure, a member of the public remains dissatisfied with the ICO's handling of any particular case, the Parliamentary and Health Service Ombudsman has responsibility for undertaking independent investigations into complaints about government departments and a range of further public bodies that includes the Information Commissioner's Office. Therefore, it is open to my honourable friend and his constituents to pursue his concerns about the ICO with the Ombudsman. Complaints procedures may appear formal, but they do provide a way for members of the public to have their complaints against their actions, public organisations and agencies to be reviewed by public bodies.